Hello and welcome to Legalbytes. If you're new here, my name Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. Hello. Welcome, everybody. Happy Tuesday. I hope you guys could hear that intro because for some reason on my end, I couldn't hear it. But then when I listened to like the YouTube side of things, it seemed like it was coming through okay. But no one was in the chat saying that they couldn't hear the intro. So I'm guessing everything is fine. Anyway, with all of that said, good morning, good afternoon, good evening, wherever you are watching this from. I hope you are having a wonderful day, wonderful Tuesday, and that your week is off to a good start. I am just enjoying making this space as Christmassy as possible. So as you can tell, I changed Indy's chair a bit, so it's even more Christmassy now. If she would actually like lay in it, that would maybe be helpful. But you know, she's on the floor here. It's fine. It's fine. It's all good. Anyway, let's see where people are coming in from. I love this is one of my favorite parts. Let's see here. We've got Mantha Johnny. Good morning from the officially cold Montreal. This week starts from the official snowfalls. Ooh, cold. Hopefully you got some good gear though. Pamela C. talking about how cold it is in Arizona. Servan, I'm so sorry. Servan Saradek, I think. I'm so sorry if I'm mispronouncing that. Hello from France. Bonjour. Brittany Chanel, good morning from Illinois. We've got Angel Baby 4210 from Fargo, North Dakota. And we've got a bunch more people here. Janneke Vandelaar from the Netherlands. I don't know why I was going to start to say New Orleans. Let's see here. And we've got Allison Watling from Michigan. We've got Paul Juarez from Texas. We've got Shibaka Wookie. I can't talk today. From Quebec. Good morning. Pamela C. from Arizona. We've got Danae Hicks from Texas. Magnus Prime from Oklahoma. AK from Germany. Andrea Kopp from Scotland. Oh, sorry. I meant to keep that on. From Scotland. We've got Miss Aka from Lanai, Hawaii. Awesome. I don't know if I've ever caught up on anybody from tuning in from Hawaii on here. So that's awesome. Aloha. We've got Cheryl Nunn from the UK, Tori Matthews from Seattle, Debbie Campbell from Washington State, Princess Candlewax from Plymouth, Massachusetts. Let's see. Oh, and we've got someone from Australia. Peta from Australia. Welcome. And oh, look at this. We've got Uncivil Law in the chat. Hello from South Carolina. Do you want company? Hey, you know what? I wasn't planning on it, but sure. My plan was to read through the appeal today, but I'm still going to do that. But we can do it together. How about that? We'll add some lovely Kurt snark. So check in your DMs, Kurt. I'm about to send it to you right now. I'll send you the link here. Gotta find you here. Here we go. All right, cool. It is in your DMs. So come on over, Kurt. So, alrighty. So, like I said, while we're waiting for Kurt to join us, we've got some interesting stuff today. I mean, as everybody knows, There is, of course, the appeal in the Johnny Depp versus Amber Heard case. As everyone, of course, knows, Johnny Depp pretty much won the trial, right? I mean, other than Amber Heard did win on one of her claims, so both sides are appealing now. We've already seen the Johnny Depp appeal brief. I did that in VOD form. I didn't do it in a live stream because I wanted to sort of truncate that one. But this one, I wanted to jump on it a little bit faster. So I might still do a VOD just to do like the bare bones of the arguments here. And for people that don't have time to sit through a long live stream to understand what her appeal arguments are all about. So I might still do a VOD on that as well. But for now, I at least wanted to go through the appeal with some relative speed here, right? Because it's been, I guess it was technically filed on the 23rd, on November 23rd, and Laura B just got it yesterday. I saw that Laura B, she had it on Twitter. And I think she already had a video out on it. So I anticipate everybody's going to have their take on this appeal as well. So, and fair warning, I have basically just started looking at it. So I haven't looked through the entire thing. So we're going to kind of wing it here. Hey, Kurt, how's it going?
Hello.
How are you doing? How was your Thanksgiving?
Happy Thanksgiving. I hope you had a great one with you and yours. I am visiting my family in South Carolina, the Palmetto States, and I'm
Lovely.
enjoying being here. And I figured I'd spend an hour with you or so, and then spend some time with my mom.
Sounds good. Sounds good. Mom time is always good time.
Yes.
So, okay. So let me pull this up then. And we can kind of go through it. I'm actually going to skip ahead through like the first third of it because I don't know if Kurt, have you gone through this on your channel as well or no?
I have. Sadly, I've gone through both of them line by line, and all I can say is don't do it. Save yourself.
So yeah, it's about 68 pages, this appeal brief. So I decided to go through and kind of skip through the whole their factual argument about like, you know, what happened to how they were married and then quickly divorced and then the you know, the what is it, the temporary restraining order, blah blah blah, all the way through the trial. It's basically like that basically is about it, right? That's a summary of like the first 20 pages or so.
Depending on which brief we're talking about. Yeah, there's the one where the jury is wrong and they're a bunch of idiots and don't know the facts like we do. And then the other one, which is actually pretty good from a position of trying to do a lot with not much. And I actually admired it in sort of a Machiavellian way. So yeah.
Sounds good. Sounds good. Also, Shireen, thanks so much for the member chat. I see in there. Deep breaths, people. Deep breaths. Yeah, it's probably going to be frustrating, but we'll go through it together. And also, Nicholas Darrow, Labor Law Santa, thanks so much for your super chat. It says, Kurt, muted screaming incoming. Did that happen during your stream?
Not so much with the muted part, but yeah. I think my brain reset a couple times. Because there are a couple periods where I blocked out for a while. Then I'm like, where was I? Okay.
Awesome. I'm so looking forward to this. And also, Shireen, thank you so much for gifting 5 Legalbytes memberships. Very kind of you, very generous of you. And to all the folks that are now Bite Club members, welcome to Bite Club. And I hope to see you guys on Friday for our next members only live stream casual hangout. So where we just basically hang out, chat in the chat, and just talk about whatever. Not even necessarily
law. Is this actually Amber's brief?
Yes.
Oh, I haven't covered this yet. I haven't seen it. Oh, I was talking about the amici briefs. I haven't seen Amber's brief. Oh, this is all brand new for me. How exciting.
Oh, okay. Even better. Even better.
I'm sure it'll be so much better than the other ones.
Yeah. 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 Well, anyhow, we'll see. We'll see. So I'll actually, let me just, let's see, this is page 10. So I'll scroll up so that you folks can see what the cover page here looks like. Yep,
brief of
the appellant.
Okay.
Yep.
That's Amber
Laura Heard.
Bring it to me, baby.
It is. It is. And so I mean, we can first start going through the basic outline here. Basic arguments here are: the trial court erred by not dismissing Depp's claims prior to trial. Trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. Okay. 3, the trial court erred in failing to grant a new trial for multiple reasons. Talking about evidentiary errors that severely prejudiced Heard at trial. The trial court erred by not dismissing the claim based on the headline for the web version of the op-ed because, so this is a little long. It's going to go a little long. And then, so a number of these things here. But I think that the first, I mean, generally speaking, when it comes to these kinds of briefs, I mean, you know this, Kurt, but for viewers and whatnot, strongest arguments usually are going to come up first, right? So you want to put your strongest.
It's sort of the ideal. They're kind of in order of,
yeah.
You want to lead big. Sometimes you'll put a really good one right at the end too, sort of the sandwich method, and put some crap in the middle. But yeah, that's generally one of your two strategies.
Exactly. So I anticipate this first section being the meatiest, and then 2 and 3 probably not so much. So, alrighty. Well, okay. Let's go down. Let's skip on down to page 10 here. Okay, yeah, we can go past the assignments of error, statement of fact. Oh, I think there is a slight echo. I did see that in the chat. Do you have earbuds by any chance?
I don't know if I actually have earphones around, so if that's a problem, I might have to break off because I'm traveling and I don't know that I have earphones with me. Well, let me see what I can do.
It's very faint, so I mean I don't know.
I tried turning down the speakers of the laptops enough so that they wouldn't be picked up by the mic. Enough though I could hear it. I'll try turning down the speakers to 5%. Let's see if I can hear that.
Okay, sounds good. Can you hear me now?
Yes.
Okay. Okay. Yeah, it's not a terrible echo. So okay. Yeah, I think it's basically gone. Yeah, I think the echo's basically gone at this point. Okay. All right.
I just have to listen very carefully.
Yeah, sounds good. Okay. Part 1, the trial court erred by not dismissing Depp's claims prior to trial. For each of 4 independent reasons, the trial court should have dismissed this action prior to trial. All right. Why should they have dismissed his action? The trial court should have dismissed Depp's claims on the ground of forum non-conveniens. Basically, forum non-conveniens means that the forum in which Depp decided to file this case was not the most convenient jurisdiction for him, even though technically it was proper, not the most convenient jurisdiction for the parties, and so therefore there was a better place for them to sue, and so therefore they should sue there. It is it's something that can be brought up by the defense attorney or by the defendant, or if it's such a bad issue, it can be brought up by the court themselves. So, but apparently, let's go through because I don't even remember this coming up as an issue during the trial, or leading up to the trial from my research before the trial itself. If they actually argued this, I mean, obviously they would have to have argued it in order to preserve it for appeal. But okay. Well,
this case should have never been tried in Virginia.
That's exactly what they're saying. This case should never have been tried in Virginia. The record overwhelmingly demonstrated that Virginia had no meaningful connection to Depp's claims and that California was the only appropriate venue. The trial court therefore erred in denying Heard's motion to dismiss the action for forum non-conveniens, and Depp's claims should now be dismissed without prejudice for this reason. Okay. And so when they mean by dismissed without prejudice is that they, as in other words, the court should have dismissed his claims, but allowed him to refile elsewhere. Virginia's forum non-convenience statute permits a trial court for good cause shown to dismiss an action brought by a person who is not a resident of the Commonwealth without prejudice if the cause of action arose outside of the Commonwealth and if the court determines that a more convenient forum which has jurisdiction over all parties, is available in a jurisdiction other than the Commonwealth. Okay, the trial court's decision is reviewed for abuse of discretion. Ooh, already.
Good luck.
Yeah. Already this is a pretty high burden for Team Heard to overcome. Because anytime the court has discretion, abuse of discretion means like she had to be on something that day. To like there couldn't have been any possible like reasonable reason for her to decide the way that she did, in other words. So this is a very high burden to overcome in terms of the appeal. A court abuses its discretion when it makes an error of law. Here, the trial court made an error of law in concluding that Depp's defamation claims arose in Virginia rather than outside the Commonwealth. Had the trial court correctly applied the law in this regard, then it would have been required to consider whether a more convenient forum with jurisdiction over both parties was available. The evidence before the trial court clearly demonstrated that California was such a jurisdiction, but because of its erroneous legal conclusion, that always reminds me of Chicago. The trial court never even considered the substantial inconvenience and prejudice that litigating in Virginia would impose on Heard. Okay, I mean, unfairly on Heard or just on Heard and also on Depp? Because if it's something that would have been tough for both of them, then what's the issue here? One, Depp's defamation claims arose outside of Virginia. The trial court ruled that Depp's defamation claims arose in Virginia solely because the Washington Post uploaded the op-ed on the internet via computer servers located in Springfield, Virginia. That ruling is inconsistent with Virginia law as applied to internet publications, which dictates that Depp's claims arose in California. Virginia adheres to the rule of lex loci delicti, or place of the wrong, to determine where a tort cause of action arises. I mean, yes. For defamation claims, Virginia courts have defined the place of the wrong as the state where the content at issue was published. Neither the Virginia Supreme Court nor this court, however, has addressed how that rule applies to defamation claims based on internet publications which reach an audience in multiple states simultaneously.
That's not quite right. The place of publication and the place of where it's consumed are two different issues, and the internet doesn't necessarily make this a new problem. If you print a book, it's printed presumably in one place and then distributed and read in other places. So I don't know that the internet really creates a novel problem in this respect. The content being read in California doesn't really speak to its place of publication in this sense.
Yeah.
I don't think that's a novel. Yeah.
Yeah. And then also, my understanding was that there were multiple reasons why the court found that this was properly in Virginia. The servers being in Virginia was one of them, but another was the fact that it was locally published in Virginia. And yeah, I think so. There are multiple ways in which this was properly tried in Virginia. So, okay. The trial court incorrectly.
And also, if it's true that neither the Virginia Supreme Court nor the U.S. Supreme Court has considered this question before, then how did the trial court abuse its discretion in considering what you conceive is a question that's never been decided by law?
Fair. That's another fair point. The trial court incorrectly concluded that publication for purposes of online multi-jurisdictional cases occurs when the defamatory statement is uploaded to the internet. To the contrary, under Virginia law, a statement is not considered to be published until it is seen or heard by a third party. Uploading content to the internet is not enough to constitute the completed tort of defamation. Instead, a third party must also receive and understand the content. Because the op-ed reached readers everywhere at once, the trial court had no basis to find it was published in Virginia rather than California or elsewhere.
Fair enough. I mean, if that's what Virginia law says, then I stand corrected. If it's true under Virginia law that for it to be published, it has to be read or it doesn't count, then okay, then uploading it to the servers would definitionally not be enough. It wouldn't be enough until it was read. It was read in Virginia, presumably, but then again, you're back into this sort of question of, well, it's read everywhere. And then we fall back into this US Supreme Court case called Calder, which I think was 1981, dealing with, or 1983 maybe, dealing with the, who was it? It was one of the gossip mags. It's the most well-known. Who is it that publishes at the newspaper, the supermarket aisle that, you know, makes really absurd claims?
Are you thinking of Us Weekly?
No.
It's been a minute since I've been in an American grocery store.
Inquirer, National Enquirer is what I was looking for. Thank you, chat.
Got it.
Yeah, National Enquirer. They ran into the same specific problem. So National Enquirer was printing a magazine, as they do, and distributed everywhere, and including, of course, California. And someone in California wanted to sue, and National Enquirer basically said this exact same thing. So Calder basically was about, when is enough enough? When does it become enough to have it in that particular state? And then Calder, at least in that specific case, the Supreme Court ruled that the person that they were interviewing was in California. The story was about something in California, and the vast majority of the newspapers were a significant percentage, 20%. The plurality of papers were published in California. The highest plurality, like 20%, were published in California, and that becomes enough. So if we want to apply Calder to this situation, then we're into the situation where if it's true under Virginia law that it's not published until it's read, then we might run into a due process problem under Calder by saying, well, someone must have read it in Virginia, so that's not enough. So actually, this could be a sophisticated legal argument. So, hey, we're not doing too bad so far.
All right. All right. And Andy, the game maker, I see you in the chat. Wait, don't worry. We got it. We got it. It's National Enquirer. We get it, you troll. Okay. So, okay. So they may have an argument here, although, like I said, there's still the issue of it being locally printed in Virginia. But then also, then the question is, well, why not Virginia if it was also read by people in Virginia? So that still seems like that's a proper place for it to be tried. Of course, when it comes to forum non-conveniens, then the next question after this would be, you know, is there a more convenient place for them to try this case? But it's not just is it easier on the parties? It's also like, you know, would there be a viable case in that other jurisdiction? Is that other jurisdiction a proper place to hear this case? There's a whole other series of questions that need to be asked for that.
True enough.
Okay. Numerous courts interpreting Virginia law have concluded that the place of the wrong for internet defamation claims is where plaintiff incurs the greatest reputational injury, which typically is their home state. Funny that she's now talking about her home state being somewhere in the United States after her.
Does she have a home state?
Argument.
That'd be nice to know. Well, she could have at the time, because
homeless.
We're going backwards in time, right? The point of the defamation would be when Amber Heard presumably republished it. At the latest time it would be when she republished it on Twitter. So at that point in time, where was her residence? In California. So we might be okay.
Yeah. Yeah. Here, that state was California, Depp's home, and the trial court abused its discretion in holding that his claims arose in Virginia. I mean, but they still haven't. I don't know about them abusing its discretion. Do you think based on these arguments here that they can overcome an abusive discretion standard?
I don't think they're making the right argument. I think Calder is the best case on point from the U.S. Supreme Court. And they can make a due process argument, basically about sufficient minimum contacts, kind of transmit that kind of idea and say, well, there's not enough here for Virginia to have a basis in its state. So the place where it would be where Virginia would be where Amber Heard performed the act, and that would presumably be California.
Okay.
So I to the extent there's an argument here, I don't think it's well argued.
Okay.
I've got better.
Well, here's also from Real Laura B. Thanks so much for the super chat, Laura B. Our our resident Depp v. Heard historian. She remembers all of these details about how the judge ruled and why throughout since the very beginning of this case. She says the judge ruled out NYC agreeing ACLU served as her agent. So didn't the editor of Washington Post be the first to read? Yeah. So that would also be yeah, no worries.
So if you could show that the ACLU performed its acts in Virginia, then that'd be fine.
Yeah. So then, then that would be
because then Amber Heard performed her acts in
party.
Virginia. That's the nature of agency.
Yeah, unless her argument becomes no, they Washington Post helps me. No, because she submitted it, right? Because the editing was done by ACLU. She like co-wrote it basically with them.
Editing is charitable. They wrote it. The editing was done by Amber Heard to the extent there was any. Yeah.
Yeah. Well, sure. You're right. But the back and forth that we saw at trial of like these emails that went back and forth between the two, that was between her and the ACLU, not her and Washington Post. Washington Post was just the final destination for it after she went through the whole process with them.
Yeah.
Okay. Yeah. Thanks for that, Laura. Okay. 2, Virginia was a completely inconvenient forum because the trial court erroneously concluded that Depp's claims arose in Virginia and Heard therefore had not met the prerequisite to dismiss the case based on forum nonconvenience. It did not consider whether there was good cause to dismiss the action.
I'm really disappointed they spent as little time on point 1 as they did. Maybe they believe it's a worse argument than I do, which is fair enough because this is the first time I'm considering it. And maybe when you do a fuller analysis, it doesn't work for the reasons I thought. But it's like if basically point 1 is this is a legally improper place. Point 2 is it's a legally proper place, but it's not the most convenient place. So point 2 you lose on because if it's a legally proper place, the plaintiff gets their choice of venue. To overcome that, you have to show basically that as they say, like it's manifestly inconvenient, it's manifestly unfair, right? So if there are multiple valid places, plaintiff gets their choice, and to overcome that, you need a lot. So point 1 is your better point. If you can make it, this is a legally improper place, but they spend almost no time on it. It's a weird structure.
Yeah. I don't know. Well, let's see how much in depth they get here. Oh, and I'm getting a little bit.
If I'm talking too much, by the way, you can tell me to shut up.
No. You're great. It's just the echo that's a little bit distracting for me at the moment. Oh, there you go. Okay. Good cause includes, but is not limited to, the avoidance of substantial inconvenience to the parties or the witnesses. Okay. So yeah, substantial inconvenience. Keep that in mind, guys, because inconvenience to the parties is not a big deal. All of litigation is an inconvenience to literally everyone involved. It has to be substantial inconvenience to the extent that it is causing some real issues. Had the court analyzed good cause, it necessarily would have concluded that Virginia was a completely inconvenient forum for this case. None of the conduct relevant to Depp's defamation claims occurred in Virginia. Depp is a resident of California. The incidents that led to Heard obtaining the restraining order took place in California, not Virginia. Heard wrote the op-ed in California and then sent it to the ACLU in New York. The ACLU provided the op-ed to the Washington Post, which published it online. Heard had no contact with any Washington Post employee. To the best of her knowledge, Heard had never set foot in Virginia prior to this lawsuit. In short, the Washington Post's computer server's presence in Springfield is the only connection between these claims in Virginia, which means Depp's choice of forum is entitled to little weight. In contrast, both parties and most of the fact witnesses were located in California, with none of them located in Virginia. Okay. Because of this error, Heard suffered substantial prejudice in two ways. First, and most significantly, Heard was unable to subpoena any witnesses for the 6-week trial and was forced to rely almost exclusively on deposition designations to defend herself. Okay. Forum nonconvenience considerations include availability of compulsory process for attending of unwilling witnesses. For attendance of unwilling witnesses, I should say. Gloria Everson, thanks so much for your super chat. Okay, so, and then they said to Norfolk, which it's describing the presentation of deposition testimony at trial as a less desirable procedure, which deprives the trial judge and jury of the ability to evaluate the witnesses in person. The lack of compulsory process meant, first, that the only live fact witness Heard was able to call in her defense was her own sister. Depp, who has considerable resources from his decades as a movie star, was able to call more than 15 live fact witnesses who voluntarily traveled to Virginia from another jurisdiction or appeared by WebEx, many of whom are employed by or otherwise financially linked to Depp. Employed by or otherwise financially linked to Depp. Basically, they're trying to toss that in again of like, oh, hey, so oh, what's this?
Okay, audio. Let's see if this solves the problem.
Oh, okay. What'd you do here?
Okay, so I don't have them. Okay, so my microphone, my microphone that I have, my lav mic, isn't working with my PC. So what I remembered, because people kept talking about the echo, is like, oh, I can hook it up to my iPhone because I have the connector for that. Get the audio from my iPhone, and I still can get the video from my webcam. So now you get all the best experience without the echo. Hey, we solved the problem.
Perfect. Hey, I love it. I love it. Very, very creative solution.
We solved the problem.
I'm very happy with this. Okay, cool. Hey. There we go. I like it. I like your ingenuity. Okay, so there is a slight echo still.
Lord, really?
It's so minor though. I think we'll be fine. Okay, but it's what I was just gonna say is that it's funny here how they are once again, of course, talking about how Depp's witnesses are all employed by him or somehow financially tied to him. They tried to do that with the jury, or making that point to the jury to be like, oh, you can't trust any of these witnesses because they're somehow financially tied to him. But yeah, it's interesting that they are putting this here. But also, hey, this point of the fact that his oh yeah, the echo's gone, so it's fine.
Yay.
Okay, yeah, I think we're good. So the fact that his witnesses came voluntarily could be a testament to his considerable resources, or it could be a testament to the fact that they wanted to show up for him and Amber just didn't have anyone that wanted to show up for her because she alienated all of the people around her. What do you think, Kurt?
I don't buy that at all. I mean, Depp was able to have the people he wanted to show up for him. I don't think it was a lack of resources that caused people not to show up for Amber Heard.
Exactly.
I'm having a tough time buying that one.
Yes. Rocky, Io, all these other people that didn't show up, not even by Zoom. It's very interesting.
Yeah. I mean, Depp had the exact same problem Heard did in this respect, right? He also lacked compulsory process,
and some of his witnesses were like in the UK.
Yeah, they were, and they did Zoom, right?
Yes.
They did Zoom. They could have participated remotely. That was an option the court was apparently willing to do. So they didn't even have to travel to Virginia to participate if they didn't want to. I don't think it was the money was the problem.
No, it definitely wasn't. I'm going to adjust your mic a little bit because I'm being told yours is a little bit louder than mine. I think, okay, hopefully that should be better.
Yeah.
Right. Like her witnesses were either in California. I think Rocky was in like Chicago at the time. So his witnesses were, in California. They were in, I guess, where else? They were in California or they were in Europe, basically.
Yeah.
So how was she unfairly disadvantaged by this process over him? And by the way, Lucky, thank you so much for gifting 10 Legalbytes memberships. Thank you so much. Very generous of you once again for gifting more memberships. And to everybody that is now a member of Bite Club, welcome to Bite Club. I hope to see you guys on Friday for our members only live stream casual hangout. Okay. Anyway, yeah. Yeah, I mean, it's a decent argument at first blush to say that that the parties need to be able to compel witnesses, right? Because not every witness wants to testify, even if they're a friendly witness, right? Because it's nerve-wracking, all kinds of issues can come up, and especially in a trial as public as this one.
I'm sure the witnesses who did not appear in court voluntarily, who would have been forced to appear via compulsion, would have just super changed the case for Amber Heard. I'm sure they would have been the best witnesses, not wanting to be there and being there because they had to be. They would have just turned the whole ship right around.
Yeah. Sarcasm. Totally agree. Because I don't see Rocky or Io or any of these other witnesses who testified by deposition. I don't see them testifying in a way that is better, right? Like they are more likely to I don't know, to falter on cross-examination, right? Like that's a pressure cooker situation. If I'm a witness in a case like this, I would so much rather just have them submit my deposition so I don't have to actually be a part of the whole circus, right? Like it's much more difficult of a process, of an experience to actually go through and sit there with the jury looking at you, with the cameras looking at you, with the crowd looking at you, and then trying to remember, like, okay, what, like, am I being consistent with what I said before? I hope I am. Like things can definitely come up. I don't know how many of you have been in an argument with a with a spouse or other significant other, and to realize you may have said something before, and maybe it's not exactly accurate to what you are saying right now, and it sucks to get impeached, and that's just with loved ones, right? When it comes to trial, it's so much more stressful. So okay. Anyway, so yeah, this is like a decent argument, but at the same time, it just begs the question, well, what about Depp? Like how is this unfair in comparison to his situation? Depp capitalized on that disparity, arguing to the jury, you may have noticed that no one showed up for Miss Heard in this courtroom other than her sister, other than a witness who traveled to Virginia for her as a paid expert. This is a woman who burns bridges. Her close friends don't show up for her. I don't know why they kept.
Facts.
Why did? Yeah, right. Why did they include this quote in here? Is my question.
That's They capitalized it on pointing out that they have no friends who are willing to travel to help you in your time of need, because it would have been so inconvenient for them to board a plane and come over and stay at a hotel or something. Yeah. Okay, sure.
Yeah. I don't know why they included this quote, because I feel like this is going to be capitalized, for, to use their term here, by the other side in their response to this brief, to be like, it's not Depp's fault. How is that Depp's fault?
Well, it makes it easier for me as the Court of Appeals. We agree with Miss Heard's brief that this is a woman who burns bridges or close residential over.
Yep, exactly.
Lol.
Exactly. Nicholas Darrow, Labor Law Santa, says severely sliced feet, met her friends 2 days later, and not one has mentioned it. 20K photos and none of her feet, not even scars to show. Oh yeah, the Australia incident. Thanks so much for the super chat. Yeah. Not one of them. Yeah. So many evidentiary issues. In addition to the fact that no one would show up for her. Second, the lack of compulsory process prevented Heard from responding as Depp shifted his case. While Depp was able to redirect witnesses and call new, previously undisclosed witnesses in rebuttal, Heard was reliant on video deposition testimony.
I know that's possible, but in fact, were any of them undisclosed? Didn't they know about Kate Moss, and they knew about all the rebuttals, didn't they?
I think Kate Moss was on the witness list because there were a lot of questions about whether or not she was going to testify. The one that was or the two witnesses that were unknown was TMZ guy and the guy from the glamping place that they went to in Northern California. I can't remember it.
Yeah. Well, I don't know what to tell you. That's part of the redirect portion. When you can call witnesses because, well, we didn't anticipate that you were going to lie on the stand. So we didn't know that we needed to call them because
these were people who came forward themselves, right? Like they identified themselves as people who could testify on behalf of Depp. So these were people that were not known to the Depp team either. So they couldn't have disclosed them if they didn't know of them themselves. And also Debbie Face on Cook, I see your member chat, says she had a photo shoot in saltwater the next day. Yeah. So many issues there with the whole like cut up feet situation. Second, the lack of compulsory process prevented Heard from responding as Depp shifted his case. Oh, we already read that. This is precisely the kind of disadvantage the doctrine of forum non-conveniens was designed to prevent. The trial court abuses discretion in denying Heard's motion to dismiss, and this court should now reverse and dismiss this action without prejudice.
On an abuse of discretion standard? I don't think so.
This is pretty anemic, I think. Yeah. I think it's pretty anemic of an argument here. B, the trial court should have dismissed Depp's claims because the challenged statements are non-actionable expressions of opinion. Expressions of opinion are constitutionally protected and are not actionable as defamation. Statements that lack a provably false factual connotation or are relative in nature and depend largely upon the speaker's viewpoint are expressions of opinion. Whether a statement is an expression of opinion is a question of law that is reviewed de novo. So they have a bit more of a chance here, right? De novo, meaning that the appellate court reviews this issue from scratch, from new.
Mm-hmm. They don't give the trial court decision any sort of weight in their determination. They are reviewing this from the beginning. And this is true. I mean, when it comes to defamation, when somebody's stating an opinion, that is not the basis of a defamation action. The three challenge statements, with the exception of the portion of the headline stating "I spoke up against sexual violence," which obviously is true. Well, what do you mean, which obviously is true? I spoke up against sexual violence. Well, I mean, that statement literally on its own terms is literally true. I spoke up against sexual violence. I mean, that is literally true.
I mean,
problem,
she
of course,
did.
is that in defamation by implication, the question is, well, what exactly are you speaking out about, or who are you speaking out about? But on its surface level, it's literally correct.
That portion, yes, which obviously, but also in defamation cases, you're not supposed to take the statement out of context. So, so that snippet, yes, is true.
Wait, no,
but
I don't understand this. This argument doesn't make sense. Oh, the three challenge statements, with the exception of the headline, are protected opinion.
Yeah.
Okay. I'm sorry. Carry on.
No. No, that's okay. There is no objective basis for assessing the truth or falsity of whether Heard felt or faced our culture's wrath, whether she is a public figure representing domestic abuse, or whether she saw institutions protect men. These statements are relative in nature and reflect Heard's subjective viewpoints. The trial court violated its essential gatekeeping function by allowing the jury to consider these non-actionable opinion statements. Those are not felt or faced our culture's wrath. That's not that was not an issue. That was not
It's
the
not
issue
public
here.
figure representing domestic abuse. It was 2 years ago I became a public figure representing domestic abuse, and that
which is
becomes part of the
conveniently
problem.
the one part that is left out of this paragraph here.
Yeah, I noticed.
So
What happened
yeah,
2 years ago? I'm so glad you asked. Yeah.
Yeah, they're it's like they're just like throwing
Wayne's World
confetti in
thing.
the air to be like, look at all this confetti. And like forget about like the massive like fiery pit of hell behind us. You know what I mean? Like they have conveniently left out the most important part. And yeah. So, you know, yes, these other portions of the statement could be interpreted as subjective in nature, you know, talking about how institutions protect men. That's an opinion. That's definitely an opinion. Public figure representing domestic abuse. Does she represent domestic abuse? Does she not? That, you know, I suppose that could be an opinion. You know, saying that she felt or faced her culture's wrath, that is a subjective experience that like can't really tell her what she experienced.
Yeah.
I guess, you know, but that's breaking up the statement into these tiny little pieces.
Yes.
So that
which is the opposite of what you do in defamation. Defamation is understood in its entire context.
Exactly.
Whether a statement's defamatory or not depends entirely on its context. Because a sentence that sounds defamatory might not be in the context of what it was said. And the exact opposite is true. It's like, what does it mean to the person who understands it? The person who's understanding it understands it in the context in which it's said. So you can't just break apart a statement and be like, well, this part's opinion, this part's opinion, this part's opinion. Like, even if that's true, it doesn't get you where you want to be.
Right. Right. Exactly. Because you can have certain portions of the statement that are opinion. It doesn't make the entire statement opinion if there is a portion of that statement that is objectively factual. So, you know, the part about 2 years ago, I became a public figure representing domestic abuse. It was the reference to 2 years ago. The question is, why did she need to reference 2 years ago? Because if she hadn't, then there wouldn't have been any case. If she had just said some time ago or recently, or, you know, I don't know, recently maybe could have trotted the line, but I even that would have been a little too gray, I think. Lori Jean Lister, thanks so much for your super chat. Says Elon is a billionaire and he didn't show up. Yeah, talk about resources. Yeah, that is someone who definitely has resources and could have shown up if he had wanted to. Okay, trial court should have dismissed Depp's claims because the challenge statements are not reasonably capable of conveying a defamatory implication as a matter of law. Oh, this is, I already know I'm not going to agree with this. Okay. I mean, just like a normal person with half a brain and 2 eyeballs can understand that was implication of Depp. Okay, when a defamation claim is based on the allegation that an otherwise non-actionable statement conveys an actionable implication, the alleged implication must be reasonably drawn from the words actually used. Yep, I think we got there. A plaintiff may plead innuendo to show how the words used are defamatory and how they relate to the plaintiff, but innuendo cannot introduce new matter nor extend the meaning of the words used or make that certain, which is in fact uncertain. Okay. It is not the province of an innuendo to enlarge the meaning of the alleged slanderous words. Its use is to explain matters already expressly alleged. Whether it's
Isn't that what's happening here, though? Because the words are domestic violence and abuse, sexual violence.
2 years ago.
Sexual violence in the title, and then abuse and domestic abuse in the article. And 2 years ago, I became a victim or became an advocate for, domestic abuse. And so, isn't it like, okay, we're not enlarging it. We're trying to explain what those things are talking about. Isn't that sort of in the nature of it? I'm not quite sure I see the distinction.
Yeah, no, I would agree. I would agree that, if you're reading words on a page and saying there's a certain meaning behind this, and I understand that meaning, that's what the innuendo is supposed to be properly. And that's what it was in the Depp case. It was so clear. I mean, the fact that there were other articles that were written about her op-ed afterwards that were talking about, oh, she's pointing to Johnny Depp. Like, everyone understood after reading that, oh, what happened 2 years ago? Oh, this very public thing where she showed up to the courthouse, even though she didn't have to. And then she, had this look of grief on her face, like, oh, I've just been abused, like it's everyone understood that, because there was nothing else in her life that happened 2 years before that could have possibly been her with some man or woman in a domestic violence sort of situation. So it was very obvious to the entire world. Oddly enough, if she hadn't pulled that publicity stunt at the TRO hearing, then maybe there could have been a question that people could have been like, I don't really know what this is about.
Yeah, but she had no idea that the camera would be there, even though her publicist came with her to file it, and the TMZ said no clue. None
whatsoever. None whatsoever. Just because, thanks so much for your super chat, says, if she did not include 2 years ago, could people have thought she meant the airport incident with her previous partner? Could be, or if she had made it so broad about time, I think that there were also allegations that her father was abusive or something. Also, like that was,
and in the
that
article
was something
itself,
that happened.
she talked about college level abuse, but at this point, I don't even know what that means anymore. This is one of the scary things about this whole exercise, is I honestly don't know what she means about words. So when she talks about, like, in college, I suffered, some sort of incident, I'm like, what the hell are you, what are you talking about? Because you use words so elastically, I don't even know what that means anymore.
Yeah, I will agree that is a difficulty. When we start to overuse certain terms, then the meaning just gets stretched beyond comprehension.
I love that in the amicus brief, where they were saying the term abuse is so open and so wide that it just becomes a matter of pure opinion, and it has no definition because it can't be pinned down. I'm like, that's just great. You want to turn
Words
the word
have
abuse into an absolutely meaningless word. That's brilliant work. Great.
Oh, man. Eric Clark, thanks so much for your super chat. Says, I knew next to nothing about Depp and Heard when she published this. Only knew they were a couple because of Overhaulen, and I immediately knew that she was pointing the finger at JD. Yep. There you go. Thanks so much for the super chat. Yeah. It was so obvious to literally everyone, to the extent that he immediately lost jobs. He immediately lost work. So, okay, well, let's continue on with this delightful argument. Let's see if it gets any better for Team Heard. It is undisputed that the op-ed does not mention Depp's name or the party's prior relationship. Does it really? It's really undisputed, is it? Because I'm pretty sure that the other side,
it doesn't explicitly mention that.
It's the prior relationship. It refers to 2 years. Okay, all right, maybe. Okay. It doesn't describe the 2016 restraining order or discuss Heard statements or evidence in that proceeding. Rather, the op-ed advocates for changes to laws and rules and social norms regarding domestic violence and sexual assault so that women who come forward to talk about violence receive more support. Okay, I mean, yeah, the op-ed can do can do more than one thing, right? It can defame Johnny Depp and advocate for changes to laws and rules and social norms. I mean, I think that most people watching this would probably advocate that, yeah, social norms absolutely should be changed to instead of having believe all women, to perhaps listen, or sorry, not believe all women, listen and believe, listen and investigate. Certain social norms like that should probably be changed, but maybe just not in the way that Amber Heard would prefer. Anyway, so okay, but at the same time, yeah, okay, maybe it didn't explicitly describe the restraining order or mention Depp by name, but she references 2 years ago, which this was published in 2018. What happened in 2016? What was the highlight of her public year? It doesn't take a rocket scientist to figure that out. Notwithstanding the absence of any express reference to the allegations underlying the 2016 proceeding, Depp's position is that the op-ed implies he abused Heard because reasonable readers would understand the words, 2 years ago, I became a public figure representing domestic abuse, to refer to that proceeding. Yeah.
That's kind of the idea, yes.
Yeah, right there.
You are
That's
correct,
it.
sir.
Depp
Please show us why that's crap now. That'd be great.
Yeah, exactly. Depp contends, in other words, that Heard revived her 2016 allegations simply by describing in the op-ed the public backlash she faced after obtaining the restraining order. I mean, did she actually face public backlash after the restraining order? I think things actually got better for her.
Well, she's facing backlash now, and that is after the restraining order. So in a very technical sense.
I mean, literally, yes.
It's one of the beautiful things about being a lawyer. You can say things that are literally true, even if they're somewhat misleading.
Yeah. Yeah. Depp's theory of liability extends the meaning of the words used beyond recognition. What? No, it doesn't. Okay. The reasoning in Fairfax v. CBS is illustrative. There, the court considered whether the hosts of a television news program defamed former Lieutenant Governor Justin Fairfax while interviewing 2 women who had accused Fairfax of sexual assault. The court concluded that Fairfax had failed to plead defamation by implication because the hosts had not stated that Fairfax did in fact commit the alleged sexual assaults, and the challenge commentary did not ascribe to any particular view of the underlying events, but rather focused on how persons who believe they are victims of sexual abuse are affected. I mean, that doesn't sound similar to this case at all. Similarly, in the op-ed, Heard did not recount the events underlying the domestic violence proceeding. Rather, she discussed how women who allege domestic violence are treated by society, and she advocated for changes to relevant laws and social norms. To accept, as the trial court did, Depp's assertion that a reasonable reader could understand the op-ed to imply that he abused her merely by describing the public reaction to her allegations would be to create a rule preventing any abused person from addressing the societal implications of speaking out about abuse. If that were the law, then it would become actionable in defamation to say, 4 years ago, Christine Blasey Ford became a public figure representing sexual assault. That plainly is not the law.
I'm not sure you want to bring Christian Blasey Ford into this. Is this really the example you want to go? There's so many other examples you could pick that
are not as murky as that one. I would agree.
Yeah,
I would very much agree. And we don't need to get into too much of a protracted discussion about Ford, but that was an example that to me personally was someone who came across as sincerely believing what she said, but I was not able to sort of go with her on that journey to say this is probably what happened to you because of memory, perception, all of that kind of stuff. So anyway, okay. So she was implying in her op-ed that Johnny Depp had abused her, and that 2 years ago she had become a domestic violence representative because of that. So, I mean, this I'm curious to look into this case, this Fairfax v. CBS, to see just how much detail there is in this. The other thing about it is Fairfax v. CBS. These women that made these statements about Lieutenant Governor Justin Fairfax, was there a big public battle that they referred to in these statements? Right? Like if not, then that's different than this case where 2016 there was a big public flashpoint that everyone knew and understood culturally across the United States. Everyone understood what it was that represented. And so the reference to that flashpoint then brings that up again. So anyway, so yeah, I can already see some potential differences between that case and Depp v. Heard. Okay. The trial court's ruling also contravenes the doctrine of judicial privilege. The statements Heard made in the course of obtaining the restraining order were absolutely privileged. That the statement wasn't about her statements in the course of obtaining the restraining order. It was after she got them, 2 years after, to be exact. Permitting a claim for defamation by implication premised on a person's published statement about her experiences in the aftermath of a judicial proceeding would substantially undercut the public policy served by the judicial privilege. See Donahue Construction.
No, it would properly constrain the privilege of judicial privilege. It would prevent you from saying something in court that's privileged and then being like, well, now I can just say it anywhere, anytime, under any circumstances, because it was said once in court. Like, exactly. It doesn't quite make sense.
Yeah. Yeah. And I'm definitely curious to look up this case here because to see if that really fits the point that they want it to. Because something tells me the fact that they don't have another parenthetical afterwards saying like describing blah 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 blah, inserting some sort of a quote from there specifically, tells me that maybe this is a little bit of a weaker bit of support than what they would like it to be. So I'm very curious to look that up. Yeah, no, because that also would fly in the face of the one claim that Amber Heard won in this case too, which was statements that were made in the course and scope of representation of Johnny Depp in the Sun case. And
you
those
have a lot
arguments,
more temporal proximity there in that situation than in this situation, because the litigation was ongoing.
Yes, exactly. It was like right in the thick of it at that time, is my understanding.
So you could split the difference that way too.
Exactly. What's that? Oh, because you're so sweet. Oh, thank you.
What'd you get?
I got a like a white chocolate truffle kind of thing.
Aww.
Yeah, very sweet. Alrighty. In overruling Heard's demur on this issue, the trial court relied primarily on Pendleton v. Newsom, a defamation action brought by the mother of a student who died at school from a peanut allergy. I remember this case. I remember looking into this. The mother alleged
that's so messed up.
Yeah,
that case is so messed up. Virginia is not going to look at the overturning defamation by implication law. No way.
Yeah. Yeah. The mother alleged that school officials had made statements to the public and the press in response to the incident, implying she was to blame for her child's death. For example, an official said that the school's trained professionals can only be effective if a parent provides information, doctor prescribed health plans, and the medicines necessary to carry out those plans. Unfortunately, this does not always occur. The Supreme Court held that these statements were reasonably capable of conveying the defamatory implication the mother alleged. Yeah, basically saying mom didn't do what she was supposed to do to keep her kid safe, which was not at all the case at all. Like the mom was like, here's everything you need to keep my kid safe. And they're like, oh, we don't need this stuff. Don't worry about it. We got it covered. And then the kid came in contact with peanuts and then unfortunately died. Unlike here, the statements at issue in Pendleton were in direct response to questions about the child's death and asserted that a parent's failure to communicate key information about an allergy impedes treatment of allergic reactions. Yeah, but I feel like that's a distinction without a difference. Right? Like, okay, yeah, that's a difference from the current case from Amber Heard's statement here in her
I mean,
in her
I
op-ed.
suppose there's a point in there about that they're stretching the meaning further than in the Pendleton case, because Pendleton, the implication was a lot more readily available as the idea than in here. You had to read more. You have to read more into this statement than you did in the Pendleton case, which I think, to be fair, is true, because the Pendleton case dealt with a statement from the school board in the immediate aftermath of that child's death, basically saying, parents need to bring this to our attention. And so, again, the temporal proximity element made it reading into it a lot easier about who, what, when, where, why. And here we're talking about things that happened 2 years ago, and it's not as fresh in the listener's mind. So some people might remember 2 years ago about what happened, but other people wouldn't necessarily. So there is a point to be had here about the op-ed being stretched more than in the Pendleton example. I think there's a fair point to be had there.
All right. Well, but
I don't
mean,
necessarily have to agree with the ultimate conclusion to give points along the way, though.
Yeah, no, that's true. I would agree that the time element is beneficial to Amber Heard. However, there are other elements here that help Johnny Depp, namely the fact that they are public figures, household names, and that the reference of 2 years ago, because of that, is enough in their situation. It wouldn't necessarily be in like a normal person's circumstances, right? Like if this were the school talking about the mom and the peanut allergy kid, like if there was later on down the line some sort of a reference to like, hey, make sure that you pack up the stuff that you need for your kid for whatever allergies so that we can do whatever we can, like that's not enough, right? Or to say like, yeah, we dealt with an incident a couple years ago that where there were problems, and so make sure that XYZ is done. Like that could probably not be enough, right? But that's a different situation than having two Hollywood celebrities involved.
It's a reasonable counter argument. I think that's a fair. Yeah. I think it's a fair point.
Yeah. All right. Let's see. Did I read through all of this here?
That's what I like, though. I like it when we can think out loud and consider things from various viewpoints. That's the good stuff.
Agreed. I love that way we can devil's advocate each other. Thus, the words used by the defendants readily implied a causal relationship between the child's death and her mother's actions or inactions. In stark contrast, the op-ed does not refer to Depp or say anything at all about Heard's abuse accusations or the judicial proceeding in which she obtained the restraining order. The trial court improperly allowed Depp to use innuendo to enlarge the meaning of the alleged slanderous words. Yeah, I still don't think that there's been an enlargement here. In post-trial motions, Heard made, and the trial court erroneously rejected a related point. The trial court should have held that a plaintiff cannot recover for defamation by implication where the alleged implication is based on statements that are true on their face and involve a public figure or a matter of public concern.
So yeah, this is this idea that defamation by implication should not exist in the context of a public figure, which, as they point here, apparently is the law in some jurisdictions that split this. So there are apparently some jurisdictions and Virginia has never explicitly ruled on this issue, incidentally. They ruled on defamation by implication, most notably in the Pendleton case, as we were just discussing. But they never ruled on defamation by implication when a public figure is involved. And public figure is elevated already under the Sullivan standard from New York Times versus Sullivan. And some states have gone so far as to say, okay, we're going to split the difference and say you can't defame a public figure by implication. So this is their argument for a modification of Virginia's law in light of what looks like Louisiana, Minneapolis, New Mexico, New Jersey, Colorado. So they got like 5 states that apparently split this difference. I don't think Virginia is particularly likely to go that way, but hey, it's a reasonable thing to ask.
Yeah. No, I agreed. It's an interesting point to make. And actually, the court could adopt it.
Yeah.
So, for example, Louisiana,
probably
defamation
not the
by
Court of
implication.
Appeals. I think you're going to have to get the Virginia Supreme Court to go this way if they're going to go this way. I doubt the Virginia Court of Appeals is likely to create new law in this direction.
Fair. Louisiana, defamation by implication or innuendo is actionable only if the statements regard a private individual and private affairs. All right. In Minnesota, statement about public figure that is true on its face cannot support claim for defamation by implication. Right. New Mexico, Colorado, New Jersey. Okay, all same. This court should adopt the same rule here to further the public interest in speech on matters of public concern, including speech about how segments of the public react after someone makes allegations of abuse, and hold that Depp failed to prove defamation by implication because he did not prove that the statements are false on their face. Ensuring that defamation suits proceed only upon statements which actually may defame a plaintiff, rather than those which merely may inflame a jury to an award of damages, is an essential gatekeeping function of the court. The trial court failed to fulfill that role, and this court should reverse and dismiss the claims because Depp cannot make out a claim for defamation by implication as a matter of law.
At least as the way we wish the law was, which, okay. Fair enough, I guess.
All right. Okay. The trial court should have dismissed Depp's claims because the doctrine of issue preclusion prevents relitigation of the UK court's ruling that Heard's abuse accusations are substantially true. I'm going to disagree with this one. I know it already. Just to say we can just transplant UK law into Virginia.
Virginia's likely to be offended by this kind of argument, to be quite honest.
I think you might be right. This is going to be interesting to see what results from this one. Issue preclusion bars successive litigation of an issue of fact or law actually litigated and resolved in a valid court determination essential to the prior judgment, even if the issue recurs in the context of a different claim. The public policy underlying the doctrine is to relieve parties of the cost and vexation of multiple lawsuits, conserve judicial resources, and by preventing inconsistent decisions, encourage reliance on adjudication. Put differently, one adverse litigative adventure on any one issue is enough for any one litigant. That's a good quote. But it doesn't fit in this situation. To establish issue preclusion. Okay, so for folks watching, if you don't know what issue preclusion is, it's basically where somebody files, let's say Kurt wants to sue me. He sues me in California. And then there's an ultimate conclusion in California. And let's say I win and he says, nope, I don't like that. I'm going to sue you again. So I'll sue you in New York. Then he decides he wants to do that. I can claim issue preclusion or claim preclusion, depending on the circumstances, and basically say, this has already been litigated. We don't need to reinvent the wheel. I already won. Too bad, so sad. You can't try it again. You can't get a second bite at the apple just because you're in another state. If it is literally the same claim, same parties, that's a very simple analysis to do. Where it's slightly different claims, or maybe sometimes there's a proxy party. Let's say it's not suing me, but it's suing my estate, that's, because I've passed away or something like that. There's a little bit more analysis that can be done, but basically, it has to be same, right? If there are too many differences, then the court's not going to be no, this case has not already been litigated. This is a new case. These are new issues here, involved. Nicholas Darrow, Labor Law Santa, thanks you for another super chat, says, are those cases between celebs? The ones citing to Minnesota and Colorado and places, I actually don't know. Wait, let me see here.
They'd be
Let's see
cited
if
to
we can-
public figures, as I understand it, which would be the distinction.
Yeah.
Whether they're celebrities in some sense is not how the law typically splits this. It splits it typically between public figures and non-public figures. So
Yeah,
we don't have a
yeah.
special category for celebrities.
Yeah. They're special, but they're not that special.
Yeah. So,
Okay. All right. Okay, so we've got issue preclusion here. To establish issue preclusion, a party must show that the relevant factual issue was actually litigated in the prior proceeding, that it was essential to the prior judgment, and that the prior proceeding resulted in a valid final judgment against the party against whom the jurisdiction or the doctrine is sought to be applied. In certain circumstances, the party asserting issue preclusion also must show mutuality, i.e., that the parties to the two proceedings are the same or in privity. So remember the example that I mentioned earlier of like if I die but my estate gets sued, that is an entity that would have privity with me. It would be standing in the same shoes that I would. It would have every interest in litigating it in exactly the same ways that I would, et cetera, et cetera. So, but if you have someone that might have some slightly different interests, that's not necessarily someone that has that same sort of privity. So that wouldn't be someone who could like stand in my shoes in a successive litigation. The Virginia Supreme Court has recognized that the mutuality doctrine should not be mechanistically applied when it is compellingly clear from the prior record that the party in the subsequent civil action against whom collateral estoppel is asserted has fully and fairly litigated and lost an issue of fact, which was essential to the prior judgment. The traditional rationale for mutuality does not apply when issue preclusion is asserted defensively. That is, when the defendant, a stranger to the prior proceeding, attempts to preclude the plaintiff, a party to the former proceeding, from relitigating an issue plaintiff lost in the earlier case.
isn't that what's happening now?
Yeah, I know. That's what I was just thinking.
Isn't the defendant, who is Amber Heard, a stranger to the prior proceedings of the newspaper, who attempts to preclude the plaintiff, Johnny Depp, a party to the former proceeding, from relitigating an issue that Johnny Depp lost? Isn't that what's happening here?
They're gonna try to say that there was some sort of
turn it upside down and backwards for me. That's good.
Yeah. Where the plaintiff has already had his day in court with the opportunity to produce his witnesses, to examine and cross-examine the witnesses for the other side, and to appeal from the judgment, there is no sound reason to allow him a second bite at the apple.
Didn't you just say a sound reason like just now, 5 seconds ago?
Yep. Whether an issue is precluded by a prior judgment is a question of law for the appellate court to decide de novo. So once again, this is the court of appeal is going to be looking at this fresh. The UK judgment meets all of the requirements for non-mutual defensive issue preclusion against Depp, yet the trial court erroneously required mutuality. There is no dispute that the truth of Heard's abuse allegations was actually litigated and essential to the prior judgment in the UK proceeding. The Sun published an article calling Depp a wife beater, and Depp sued the Sun, alleging that it defamed him because the abuse allegations were false. In rejecting Depp's claim, the UK court found, based on much of the same evidence presented in this case, e.g. Depp's and Heard's testimony, that Depp had engaged in at least 12 acts of domestic violence against Heard, causing her to fear for her life. The UK court therefore concluded that the defendants had proved the Sun's description of Depp as a wife beater was substantially true. There is no question that Depp had a full and fair opportunity to litigate this issue. Depp chose to file a libel suit in the UK, predicated on the same abuse allegations that he contends were revived by Heard's op-ed. Indeed, Depp's UK counsel asserted prior to trial that his client could only be vindicated by a clear and reasoned judgment from the UK court. The parties to the UK proceeding engaged in extensive discovery motions practice, and Depp also had access to the discovery conducted in this case for 16 months prior to the UK trial. I think this is going to be disputed by the other side, because there was a whole big issue about discovery that she had access to that he did not.
Yeah, but
the UK.
we're advocating for Amber Heard, so we don't have to make that particularly clear now, do we?
I guess not, right? The UK trial included 4 days each of testimony by Depp and Heard, as well as 24 other witnesses. And under UK law, Depp faced a much lighter burden of proof on his claims than he did in Virginia. In the UK, the defendants bore the burden of proving the substantial truth of the statements, rather than Depp having the burden of proving them false. Yet Depp still lost and then exhausted his appeals. In short, Depp had his day in court in the UK proceeding, and he should have been precluded from relitigating the exact same factual issue that was decided against him in that action. Accordingly, this court should reverse and dismiss Depp's claims. So no, because they don't. Yeah, they don't. They really don't go into much detail here, because this whole part about somebody that can stand in privity, it has to be the same or substantially similar claims at issue, right? So it involved defamation, but that was defamation against a publisher who was relying on a third party for information, whereas this was a case against the source of the information herself.
Yeah, claim preclusion and issue preclusion are usually very related. Like, an issue can have multiple different possible claims, right? So you did a thing against me is the issue, all right? But the claim can be multiple different things, like you defamed me, you invaded my privacy, you whatever, right? Lots of different things. So the more often situation where you see issue preclusion is where it was possible to bring claims that you didn't bring, that arise out of the same incident or the same nexus of facts. That's more often where you see it. So suppose, for example, that there was a newspaper article from which 10 claims could have been brought, right? I could have brought defamation. I could have brought invasion with privacy. I could have brought interference with business advantage and stuff like that, right? I could have brought all those claims. For whatever reason, because I'm the master of my own claims, right? I brought only 3 of those claims. My call, I get to bring them all or bring some of them, whatever. I bring those 3 claims. So claim preclusion would be me going to a different court and saying, I want to bring those exact 3 claims again. Issue preclusion is most commonly, hey, those other 7 claims, well, I didn't bring those before, so I don't have claim preclusion as to those 7 because I've never heard of them. But you say, look, issue preclusion. They emerge out of the same nexus of facts, man. There's nothing new here, right? You had the opportunity to bring those claims before. You didn't. For whatever reason, it was your call. You're bound by that decision. So, yeah, you may not have brought those precise claims before. So as to the 3, claim preclusion. As the other 7, issue preclusion. So what they're trying to do here is a little atypical, because this is a different newspaper with a different article, different country's laws, different witnesses, different facts, and the judge apparently was hoodwinked into the whole donation means pledge thing.
Yeah.
So trying to apply issue preclusion here, like, oh, this is from a common nexus of issues. Like, I'm not really. There's some underlying things that are relevant to both, but they're kind of distinct. So not 100% feeling the issue preclusion today.
Yeah, and on top of that, you've got different laws because they're different countries, right? Like it's So I think, so many issues with that other trial, and the fact that oh wait, let me see here. Did I do this?
And not to put too fine a point on it, but at this point, you're also having to make this argument in light of the jury who sat through 7 weeks and said, nah, we think that was wrong. It's true the UK standard is harder, which says more about the UK decision than I think Virginia's. But like, well, this would have been a reasonable decision to deny it, but having gone through it all, it's like, I don't think so.
Yeah.
But I appreciate the try. I do appreciate the try. It's not a completely absurd argument. I don't think it works for all the reasons I said. But at the same time, I'm not going to sit here and claim that I think it's a completely nonsense argument, right? It makes sense what they're trying to do, because as I tried to make clear in my little description, it most commonly is in this situation with a common nexus. Can you get from one nexus to another? Sometimes, but you're having to do a lot of things here. You're having to get from one nexus to another in a different country with a different set of laws and all the rest of it. So but it's not an inherently absurd argument. That being the case, however, I must now take my leave. I've exhausted my time, and I must now spend time with my mom, whom I love. So I must go on adventures with her.
Oh, yay. Well, have fun with your mom, and tell her I said hi.
And I will definitely be covering this info later on my channel. So you can look forward to additional snark and analysis with Uncivil Law sometime later today.
There you go. There you go. Well, thanks so much for joining me, Kurt. This has been wonderful.
All right. Talk to you soon.
Okay. Bye. So, oh wait, I will remove that. Okay, cool. Yeah, I'm not buying the whole issue preclusion, claim preclusion argument by Team Heard either. But of course, I knew that before we went into what specifically those arguments were. So let's see what they've got next. The trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. Okay, except that he did prove actual malice. Both under the First Amendment and as a matter of Virginia state law, Depp, as a public figure challenging statements to the public on a matter of public concern, was required to prove by clear and convincing evidence that Heard made each of the challenged statements with actual malice. Of course, actual malice is a term of art that means that the defendant either knew her statement was false at the time she published it or published it with reckless disregard as to the truth, i.e., that she subjectively entertained serious doubt regarding its truth but published it anyway. In defamation by implication cases such as this one, establishing actual malice requires making a second showing. Not only was Depp required to show knowledge of or recklessness in regard to the falsity of the statement's defamatory meaning, he also was required to demonstrate that either the defendant intended to communicate the defamatory meaning or knew of the defamatory meaning and was reckless in regard to it. Without this requirement, a defendant could be held liable for what was not intended to be said, which would eviscerate the First Amendment protections recognized by the U.S. Supreme Court. Okay, citing to Sands, which says simply because a statement reasonably can be read to contain a defamatory inference does not mean that the publisher of the statement either intended the statement to contain such a defamatory implication or even knew that the readers could reasonably interpret the statements to contain the defamatory implication. Okay. Well, that is something. So something about actual malice is it matters so much more where somebody is making a statement about a public figure that they don't have necessarily personal knowledge about it. Here we are talking about a situation where Amber Heard says, I was abused. She would know if she's abused or she's not abused by someone, right? Like this is something that she would have personal knowledge. So if you think that she made a statement about her own experience that is incorrect, it follows very, very closely to say, well, she knew that she was making a false statement because she was saying that those were things that she experienced. I mean, unless their argument now is going to be something that like Amber Heard is a crazy pants who doesn't know what she's saying half the time, like that would just be a wild argument to make. But that seems like that's like how they would have to go about this, right? Like how else is somebody going to be looking at someone like Amber Heard who is saying I went through XYZ, and then they objectively look at her as making that statement and saying, no, you did not. So, okay. Whether the trial record is sufficient to support a finding of actual malice is a question of law, and this court must take an independent review of the record. So once again, de novo. Okay, significantly in deciding this issue, this court must evaluate the record in light of Depp's burden to prove the two prongs of actual malice by clear and convincing evidence. Depp failed to meet that burden, and therefore this court should reverse and enter judgment for Heard. Part A, Depp failed to prove by clear and convincing evidence that Heard was aware of and intended to communicate the alleged defamatory implications. A person cannot knowingly or recklessly tell a falsehood if she did not intend to and was not aware that the words she used would be misunderstood to communicate such a falsehood. The evidence at trial fell far short of establishing by clear and convincing evidence that Heard had the communicative intent to accuse Depp of domestic abuse in the op-ed. The undisputed evidence showed that the ACLU proposed that Heard author an op-ed. Okay, the undisputed evidence showed that the ACLU proposed that Heard author an op-ed on the ways in which survivors of gender-based violence have been made less safe under the former presidential administration. The ACLU then prepared the initial draft of the op-ed. Heard engaged her attorneys and, based on their advice, made significant efforts to remove all references to Depp and their marriage from the draft. Well, you maybe made significant efforts, but you didn't successfully do it, because you did definitely reference their marriage by referring to an incident from 2 years prior. As Heard explained, the purpose of the op-ed was not to discuss Depp or the particular allegations she raised in 2016, but rather to discuss what happened to her in the public arena after she spoke out. Doesn't matter. It doesn't matter. She may have very well have had this intent to talk about these other issues, to talk about, the patriarchy, speaking out, blah, 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 all of these policy things that they want to point to in this appeal brief so far. But the fact remains that she still references what happened to her 2 years prior, and that is a reference to Johnny Depp. That is the man that she was divorcing in that year. So, she may have intended to also talk about all of these things, but she also referenced a claim that she made against her ex-husband that is very, very clearly intended in a very particular way. In sum, Depp presented no evidence, much less clear and convincing evidence, that Heard either intended to communicate through the op-ed that Depp had abused her, or knew of the defamatory meaning and was reckless in regard to it. Indeed, just the opposite was true. On this basis alone, the jury's verdict cannot stand. I think it's bullshit. I'm sorry, this is such a weak ass argument. Part B, Depp failed to prove by clear and convincing evidence that Heard either knew the alleged implication that he had abused her was false, or subjectively entertained serious doubts about its truth. Even if this court concludes that the record contained clear and convincing evidence that Heard knew at the time of publication that the op-ed communicated to readers the implication that she was asserting that Depp had abused her, the record contains no evidence that she knew or thought it likely that such a statement was false. Depp failed to carry his burden on actual malice for this separate reason. Okay, in this regard, it bears emphasis. There is a significant difference between proof of actual malice and mere proof of falsity. Depp cannot prevail merely by proving that the abuse did not occur. Rather, to establish actual malice by clear and convincing evidence, it was required to offer affirmative evidence that Heard did not believe he had abused her or entertained serious doubts about whether he had done so. There is no such evidence. The thing about that, though, is that was also on the what was I going to say? That was also on the verdict form. They had to check that box to say that they believe that she acted in actual malice, that she made the statement with actual malice. Depp alleged that the op-ed falsely implied that Heard was a victim of domestic abuse by him. Because actual malice is a subjective standard, whether Heard believed Depp abused her must be judged by her own state of mind. Yeah, and this is like crazy town here. To say that she to say that there could be a world in which she said, I experienced this, and then it turns out that that's false, and then to say, I didn't intend to lie when I said that I experienced this thing that I didn't actually experience. You know what I mean? Like, it's crazy pants. Heard testified unequivocally that she believed Depp had abused her physically, verbally, emotionally, and psychologically. Depp and his expert witness conceded that abuse can take many forms, including verbal, emotional, and psychological. And the trial record contains considerable undisputed evidence supporting the proposition that Heard at the time of publication believed that Depp had abused her. For example, Depp demanded that Heard cut him with a knife and threatened to cut himself in her presence when she refused to comply. Depp engaged in violent behavior in Heard's vicinity on multiple occasions, including kicking cabinets and doors, smashing glasses, punching a light fixture, and toppling racks of clothing in her closet and throwing one rack down a staircase. Depp exhibited jealous and controlling behavior toward Heard, such as accusing her of infidelity and promiscuity, which actually turns out to be true, I think, based on the text messages and video footage that we actually saw. Including messages written around the house with his own blood and forbidding her from acting in movies or having meetings. I don't know that I agree that there was evidence of him forbidding her from acting in movies or having meetings. Depp admitted to headbutting Heard, though he claimed it was unintentional. Depp told Heard on one occasion, I left last night, honestly, I swear to you, because I just couldn't take the idea of more physicality, more physical abuse on each other. Importantly, even if the jury could properly have concluded that these undisputed facts did not constitute abuse, quote unquote, and a reasonable jury could not have done so, so they say, Depp presented no evidence that undercut Heard's testimony that she believed this conduct amounted to abuse. Consequently, Depp failed to meet this burden on the second prong of actual malice, and the court should enter judgment in Heard's favor for this independent reason. And there's a question about this footnote here. The record also contains many other examples of disputed evidence of abuse, but the court need not even consider those to appropriately conclude that the trial court should have struck the jury verdict for Depp's failure to prove actual malice. The trial court erred in failing to grant a new trial for multiple reasons. For each of these several independent reasons set forth above, this court should reverse the judgment in favor of Depp and either enter judgment in favor of Heard or dismiss Depp's claims without prejudice. If, however, this court disagrees with all of the foregoing, then at a minimum, this court should reverse and remand for a new trial, again for multiple independent reasons. Part A. The trial court made numerous evidentiary errors that severely prejudiced Heard at trial. This court reviews a trial court's admission or exclusion of evidence for abuse of discretion. The trial court's numerous erroneous evidentiary rulings prevented the jury from receiving evidence highly probative of the truth of the implication Depp alleged the op-ed conveyed, and of Heard's lack of actual malice, while also permitting the jury to receive irrelevant and unduly prejudicial evidence used by Depp to attack Heard on purely collateral matters. Each of these evidentiary errors standing alone would warrant a new trial and considered cumulatively clearly mandate reversal. Okay, let's see. Let's take a look at what they mean specifically. 1, the trial court erred by excluding evidence of Depp's abuse and Heard's state of mind. Long before Heard sought a restraining order in 2016, Heard made numerous contemporaneous statements to third parties about Depp's abusive conduct. Instead of permitting the jury to consider this critical evidence, the court excluded it based on an erroneous application of Virginia hearsay. I was about to say, that sounds like hearsay. Statements about Depp's abuse made years prior to any potential litigation were essential to the jury's consideration of the facts and Heard's credibility, especially given that Depp given that Depp made Heard's credibility the linchpin of his case. Well, her credibility is always going to be at issue, as is literally every single witness. So like it's so they're saying like, oh, Depp made Heard's credibility the linchpin of this case. Okay, all right, cool, Jan. But like, no, the court is I don't see the appellate court saying, oh, okay, yeah, let's just ignore hearsay and allow this in. Heard's reports of abuse to medical providers plainly were admissible. From 2011 to 2016, Heard sought treatment from several medical professionals as the result of her volatile and violent relationship with Depp. A number of these professionals documented Heard's contemporaneous statements about Depp's abuse in medical records. The trial court, however, excluded this evidence as hearsay, properly so, because it is hearsay, which Depp then used as both a shield and a sword. Whew, okay. Got disconnected for a second there. Okay. Now we're back. Okay. Yeah. Quickly back. Sorry about that, guys. Okay. The trial court, however, excluded this evidence as hearsay, which Depp then used as both a shield and a sword. Not only did Depp convince the court to preclude Heard from presenting relevant admissible evidence to corroborate her claims, but Depp then weaponized that exclusion, arguing to the jury that such evidence did not exist. Ms. Heard has told you that she has mountains of evidence of abuse, but there are no medical records reflecting she sustained any injuries from this abuse she claims. That statement is unequivocally false. The trial court had wrongly excluded those very mountains of medical records created from 2011 to 2016. Okay. I mean, that is based on her testimony. They asked her if she ever went to the doctor after the Australia incident, after supposedly getting hit with a phone, after, all of this stuff. So they asked her when she was on the stand. Camille Vasquez asked her when she was on the stand about seeing any medical professionals after these alleged incidents. And she said, no, I didn't. So that's the only way that they were able to even argue that in closing. So yeah, and these contemporaneous statements about, allegedly about Depp abusing her in medical records. The reason why that is excluded is because that's not the best evidence. You get these medical professionals, you get them to testify. Because otherwise, this is just improperly bolstering what she said before. Because essentially, like, just because she said something to a doctor, let me do this here. Just because Amber Heard said something to a doctor, right, to a shrink about things that she experienced with Johnny Depp, she can say the thing, doesn't necessarily mean that it's true. The act of the doctor then writing it down in their notes that she said XYZ does not make it any more true. So the problem with admitting those notes at trial in a case like this is that it would potentially mislead the jury into thinking that just because it's something that's been written down by a doctor, that suddenly it is more true than false. That suddenly there is more credibility, there's more accuracy to the things that she told the doctor, when literally the only difference is that it's the statement has been written down as a note by a doctor in the course of treating her. It doesn't make it any more accurate at all. And also Miranda Hike, thanks so much for the super chat, says statements, not physical evidence. Right, because what they were getting at was medical records showing the different injuries and whatnot that she was going to be going through, that she had experienced as a result of these things. So yeah, but statements can be evidence as well. I mean, depending on the circumstances. Also, so sorry I missed this one. Gigglin SC, thanks so much for the super chats. So how long will it take to find out if the appeal is granted? Well, both sides are now going to be responding to the other side's briefs. I don't know exactly how long, but I anticipate this to take a while. So don't hold your breath for too long on this one. And also I missed this one. Diane Lionheart, thanks so much for your super chat. There's one point Kurt muted himself for a bit. Oh no. Okay. Alrighty. So I'm all caught up on super chats now. And okay. Virginia's hearsay rule precludes introduction of an out-of-court statement offered to prove the truth of the matter asserted only if that statement does not fall within one of the recognized exceptions to the rule. One exception is for statements made for purposes of medical diagnosis or treatment. Okay. Citing to Curtis v. Stafford County Department of Social Services, medical and psychological records that included victim statements were properly admitted under this hearsay exception. The trial court should have admitted Heard's statements to medical providers under this exception. My guess is that this is similar to the business records exception, which basically, like, there's got to be a whole long list of there's got to be a whole long list of factors that it has to fall into in order for the writing to fit into this exception for, the exception for statements made for purposes of medical diagnosis or treatment, because that's what happens with business records, right? Like, just because a business has a certain piece of paper that says something doesn't on its own make it automatically admissible outside of, like, the hearsay rule, right? There are certain reasons why certain documents that are business records can be admitted, and it's because, like, if that business is in regularly keeps these kinds of records, this record is, it's basically within the same course and scope of, like, other records that they keep on a regular basis. All of those factors are intended to ensure the accuracy and credibility of that document, and to ensure that the purposes for which that document is being admitted are proper. Same thing is, my guess is that the same thing in Virginia would be the case for any kind of medical records, medical or psychological records. You can have statements by a patient in a medical record that fall into the exception or that don't. So anyhow, let's see if they actually list the factors here, or maybe we'll have to wait until the response brief, right? Okay. The trial court, should have admitted it, blah, blah, blah. Separately, the trial court should have admitted Heard's prior statements about Depp's abuse as non-hearsay assertions offered to prove Heard's state of mind. It is black letter law that statements admitted as evidence of an individual's state of mind are not hearsay. A statement that is offered to prove a state of mind is not hearsay because it is not offered for its truth. Because of Depp's burden to prove actual malice, Heard's subjective state of mind regarding whether abuse occurred was a primary issue in this case. Thus, evidence that she subjectively believed she was a victim of abuse was critical. Okay, but you can get that directly from her on the stand. She testified in person on the stand. So I don't see this being a compelling reason at all for why these medical records should have been admitted, because at the same time, the reason why she wanted those medical records to be admitted was not for her state of mind. It was so that she could point to those documents in front of the jury and say, "Yep, see, doctor took it down that I said that I was abused, so therefore I was abused." That is the definition of hearsay. James Morris, thanks so much for your super chat. Says, when can we expect to get a result from the Court of Appeals? Not for a while. I like I said before, the other side is going to need to be able to file a response brief. Amber Heard's going to be filing a response brief to Johnny Depp's appeal as well. And then there will be oral arguments. So all of this is likely to take some time. I don't know exactly when. But just not any time in the immediate future, I would say. Shibaka Wookie, thanks so much for your super chat. As Dr. Spiegel says, you just need to watch movies to evaluate the sanity of an actor. I've been watching Drive Crazy, the trial represented right there. There you go. There you go. Boom. Thanks so much for the super chat. Okay. Because of Depp's burden to prove actual malice, I already read that part. Okay. Thus, the evidence that she subjectively believed that she was a victim of abuse is critical. You get that from her testifying, okay? I said that before, but I'll say it again. Here, the trial court improperly prevented the jury from considering several separate instances in which Heard reported Depp's abuse to a medical professional. From 2011 to 2014, Heard was treated by clinical psychologist Bonnie Jacobs. Dr. Jacobs' contemporaneous medical records show Heard repeatedly reported Depp's abuse. For example, in August 2012, Heard reported Depp was in a rage, accused her of cheating, and threw a glass by her head. In September 2012, Heard reported Depp was violent and ripped her nightgown, threw her on the bed, tried to have sex, but couldn't get it up, became more angry. And on November 15th, 2012, Heard reported sometimes Johnny becomes verbally and sexually abusive after spending time with father. Okay. So once again, these are statements made by her. Seemingly to offer these statements as truth. To say that she was abused, not that she believed that she was abused. From 2014 to 2016, Heard was treated by psychologist Connell Cowan. Dr. Cowan's records reflect that in December 2015, Heard reported that Depp was physically abusive and that he started the physicality pushed her down. From 2014 to 2016, Heard sought treatment from nurse Erin Filati for injuries caused by Depp. Filati's notes reflect that on December 16, 2015, Heard reported that Depp headbutted her, and on May 21st, 2016, Heard reported that Depp hit her in the face. In 2015 and 2016, Heard and Depp saw Laurel Anderson, a clinical psychologist who was treating them. During therapy sessions, Heard reported that Depp slapped her, hit her in the head, pulled her hair, and kicked her in the leg, causing her bruises. In 2015 and 2016, Amy Banks, a clinical psychologist, treated Heard and Depp. In a joint session, Heard discussed Depp's violence, which he did not contradict. This could have also been one of the sessions where Depp was just not really participating because as some of the testimony reflected during the trial, when the two of them were in a session together, he wouldn't really participate much. But then when it was just him with the therapist, he would be like an open faucet. So if he didn't contradict, was he actually even participating in the first place is a valid question. These statements, which were made long before Heard would have had any motive to fabricate allegations of abuse, each should have been admitted as statements made for the purpose of obtaining medical treatment for both emotional distress and physical injuries, as well as statements showing Heard's state of mind. Moreover, each of these statements about Depp's abuse, whether made to medical professionals, friends, or family, also should have been admitted for the independent reason that they are prior consistent statements. Okay, citing to Rule 2801 D2, a prior statement that is consistent with the hearing testimony of the witness is admissible for purposes of rehabilitating the witness's credibility. Ordinarily, proof of statements made by a witness out of court cannot be received to corroborate his testimony, but such statements may be admitted where the credibility of the witness has been assailed on the ground that his story is a recent fabrication or that he has some motive for testifying falsely. Once Depp attacked Heard's credibility and accused her of fabricating her allegations of abuse, the trial court should have permitted Heard to introduce these prior consistent statements. If not reversed, the trial court's exclusion of contemporaneous reports of domestic abuse to medical professionals will make it more difficult for other abuse victims to prove allegations of abuse and likely deter them from coming forward. Okay, well, I'm going to piece that up a little bit. So, okay, so saying that these medical records were prior consistent statements. Okay, just because her credibility is being attacked doesn't mean that you can come forward and bring up all of her prior consistent statements talking about abuse generally. They have to be very narrowly focused, right? So if they went into, let's say specific instances from 2015 and 2016, right? Like, Heard reported that Depp slapped her, hit her in the head, pulled her hair, kicked her in the leg, causing her bruises. Like these specific incidents, if those came up on cross-examination to say that, no, you didn't do this thing, then on redirect, yeah, you could bring those in, but it would have to be very narrowly tailored. It would have to be very focused. It doesn't mean that you can bring in all of these contemporaneous statements here. Okay. If not reversed, the trial court's exclusion of contemporaneous reports of domestic abuse to medical professionals will make it more difficult for other abuse victims to prove allegations of abuse and likely deter them from coming forward. No, because this would be to say that they are getting rid of the hearsay exception for contemporaneous or for prior consistent statements for these kinds of things. Amber Heard's team, they keep trying to turn this into a bigger like widespread argument than it really is and is meant to be, which I think is highly improper. Part B, the trial court wrongly excluded corroborating testimony of Heard's allegations. The court improperly excluded a text exchange in which Depp's agent, his personal assistant, Stephen Deuters, corroborated Heard's allegations of abuse on a flight from Boston to Los Angeles. A statement by the party's agent or employee made during the term of the agency or employment concerning a matter within the scope of such agency or employment is an exception to the hearsay rule. Okay, on May 25th, 2014, Deuter sent a text message to Heard stating, "When I told Depp he kicked you, he cried." Deuters sent Heard this message after Depp told Deuters to smooth whatever issue existed with Heard by texting Heard and telling her whatever she needs to hear. The trial court should have admitted this evidence as a party opponent admission because Deuters was an agent of Depp, and Depp specifically instructed Deuters to communicate with Heard regarding the altercation. Given Depp's attacks on Heard's credibility, this text message was critically important. I don't know, though. That could be outside the scope. That could be outside the scope of his employment. And again, this goes to the issue that the better way of admitting this kind of evidence is to talk to Deuters himself at trial. So, why didn't they call him as a witness? The trial court improperly excluded the UK judgment. Prior to trial, Heard opposed Depp's motion in limine to exclude the UK judgment, and during trial, Heard sought to admit the judgment after Depp opened the door to the evidence on numerous occasions. I had to wait for my opportunity to address the charges, and so today is my first opportunity that I've been able to speak about this case in full for the first time. That doesn't open the door. There could be plenty of reasons why there could be plenty of reasons why he didn't have an opportunity to address the charges. While the trial court allowed references to the UK proceeding, it precluded the jury from learning about the outcome. Admitting the UK judgment would not have been unfairly prejudicial to Depp, but its exclusion unfairly prejudiced Heard in at least two ways. Okay, let's hear about that. First, the court's decision to allow Depp to refer to the UK proceeding without explaining the outcome left the jury with the mistaken impression that the outcome of the trial was favorable to Depp, when in fact, the UK court found that Depp had abused Heard on at least 12 different occasions. You don't know that. That's an empty void that you can that is up to interpretation. The jury could have been left with the impression that Depp lost the trial. Depp promoted this misperception throughout the trial. While testifying, the court permitted Depp to read into the record the title of an article. Johnny Depp was the victim of abuser Amber Heard, London's High Court told. Similarly, Depp's damages expert testified that Depp brought the UK proceeding to clear his name, which served to mislead the jury about the outcome of that proceeding. Second, as more fully described in section 3.5 below, the Sun article that precipitated the UK proceeding, Depp's decision to file the UK lawsuit, the trial, and significant media attention, and the UK judgment finding that Depp had in fact abused Heard undoubtedly negatively impact Depp's reputation. Nonetheless, Heard was precluded from presenting the jury with this highly relevant evidence regarding damages. Because of the judicial impact to Heard and given Depp's false and misleading testimony, the trial court erred by excluding evidence of the UK judgment. No, I'm not buying that argument. The trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements. Depp alleged that Heard defamed him. Depp alleged that Heard defamed him by falsely writing in the op-ed, "I became a public figure representing domestic abuse." On cross-examination, Heard's counsel sought to ask Depp whether that specific statement was accurate. Despite the fact that Depp was required to prove the falsity of the statement as an essential element of his claim, the trial court precluded him from answering the question on the ground that it called for a legal conclusion. This was an abuse of discretion. Yeah, no. You're not to require a witness to testify to an ultimate legal conclusion is bogus. That is a valid reason for excluding his answer from testimony. Cindy Baraja says in the UK did not find him guilty of abuse. That wasn't the point of the lawsuit. True, but because of the way that UK law is structured on these kinds of cases, the defense has to prove. Okay, now I apologize if this is not completely accurate, but basically the court has to determine whether or not the underlying facts are substantially true or not. And ultimately what the court did determine was that the allegation that Johnny Depp had abused Amber Heard multiple times was substantially true. That's what they found. Whether or not we agree with that is a whole other matter. I completely disagree with that based on everything that we've learned through the Virginia case. So yeah, but I understand what you mean that was a case against the publisher for The Sun. It was not a case against Amber Heard. So there are all kinds of differences and distinctions there. Thrift with Joy, thanks for your super chat, says, I thought the UK judge actually said that at least one of the 12 incidents did not happen. That I don't know, but what I do understand is that there were multiple incidents that the judge pointed to and said, this actually probably happened. This was likely to have happened. So multiple points of disagreement between me and the UK judge, respectfully. Okay. Rule 2704A allows testimony on an ultimate issue unless the testimony calls for an opinion that constitutes a conclusion of law. Whether a statement of fact is true or false is not a conclusion of law. Whether an allegedly defamatory statement is false ordinarily presents a factual question to be resolved by a jury. Heard clearly was prejudiced by. Okay, so let's go back for a second. The statement at issue was, I became a public figure representing domestic abuse. And then Depp was asked whether that specific statement was accurate. Well, I mean, if they're asking if it's accurate, it's on the edges. It's on the edges, but I think, again, though, this is an abuse of discretion standard on this. So which means that if it's kind of a gray area, points go to the judge and the ruling stands. Okay. Whether a statement of fact is true or false is not a conclusion of law. Whether an allegedly defamatory statement is false ordinarily presents a factual question to be resolved by a jury. Heard clearly was prejudiced by this error. Depp's testimony that this statement was accurate, i.e. not false, would have required entry of judgment for Heard on that particular claim. Granting summary judgment to defendant newspaper because the plaintiff failed to carry the burden of proving the material falsity. Okay. Okay. No. The trial court erroneously admitted irrelevant and prejudicial evidence. In at least 2 instances, the trial court admitted irrelevant and unduly prejudicial evidence that had nothing to do with this case, but allowed Depp to attack Heard's character. Evidence that is not relevant is not admissible. In addition, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice or its likelihood of confusing or misleading the trier of fact. Evidence regarding specific instances of conduct of a witness, when allowed, normally is limited to cross-examination. For impeachment purposes, extrinsic evidence related to those acts is not allowed. The reason underpinning this rule is that the admission of evidence of specific acts and the rebuttal evidence which would follow injects collateral issues into the case, which would divert the jury's attention from the real issue. So basically what they're arguing here is that there was some kind of extra evidence that was admitted that was prejudicial to Amber Heard that shouldn't have been admitted because it wasn't relevant. Let's see. A, the trial court committed reversible error when it admitted extrinsic evidence of Heard's pledge to donate money to charity. This was pretty damaging to Amber Heard, right? The trial court committed reversible error when it admitted irrelevant and unfairly prejudicial evidence related to a purely collateral issue, Heard's pledge to donate proceeds of her divorce settlement to charity in 2016. While a party has significant flexibility to cross-examine a witness and impeach her, the Virginia rules of evidence limit a party's ability to introduce extrinsic evidence to attack a witness's credibility. The trial court improperly permitted Depp to introduce extrinsic evidence about Heard's pledge to donate $7 million to the ACLU and the Children's Hospital to attack her character and integrity. The pledge, which was announced 2 years prior to the publication of the op-ed, was not relevant to Depp's defamation claims and was unduly prejudicial. Indeed, Depp not only used this evidence during cross-examination of Heard, but he introduced collateral evidence, including witness testimony from representatives of the ACLU and Children's Hospital about the pledge for only one purpose: to prejudice the jury against Heard and paint her as a liar who only wanted public praise. Well, they said it, not me. And that's because you wanted the entire world to think that you were donating every penny of the $7 million divorce settlement as soon as you received it from Mr. Depp. Isn't that right? So as of today, and these are quotes from Camille Vasquez during cross-examination. So as of today, you have not paid $7 million of your divorce settlement to charity, right? And that's because you did want something. You wanted Mr. Depp's money. Well, lies. That is Miss Heard's narrative. Lies upon lies. Okay, I'll give my thoughts in a second. The testimony created a mini trial on what Heard donated, what her intent was, and whether she intends to fulfill the remaining pledge. Again, none of this related to the op-ed or whether Depp abused Heard. Excluding evidence. Okay, so the reason why this was relevant was because it gave an extra motive to her lying about the abuse, right? It was this was relevant, right? It was relevant to the extent that it was showing why would someone like Amber Heard lie in an op-ed like this? What kind of motivation could she possibly have to do something like this to another person, if in fact that is the case, right? Because it's like when we're dealing with a case like this, we have to sort of approach that sort of question. Why would she lie? This gave an answer to that. So talking about the fame, talking about the money, talking about, the notoriety, all this kind of stuff, that helped to answer that question about why Amber Heard would lie about this kind of stuff in such an egregious way. So yeah, it was relevant. It was absolutely relevant. The trial court committed reversible error when it admitted extrinsic evidence of Heard's alleged domestic abuse more than a decade earlier. The trial court also allowed improper impeachment of Heard when, in rebuttal, Depp presented testimony of Beverly Leonard, a police officer purportedly present when Heard was arrested in 2009. The court clearly erred when it admitted this evidence on an entirely collateral issue. During cross-examination, Depp asked Heard about domestic abuse he alleged she engaged in during a prior relationship. Heard denied the allegation. That should have been the end of it. However, the court permitted Depp to call Leonard, a former police officer, to testify that in 2009, she saw Heard acting aggressively toward her then partner, grabbing her partner and pulling her partner's necklace from her neck, permitting extrinsic evidence of an incident that occurred 9 years prior to the publication of the op-ed violated Rule 2608B and allowed Depp to paint Heard as a bad person. No, because she was asked a question. She gave one answer saying, this has never happened. There has never been an allegation against me of domestic abuse. And then the impeachment was, well, let's show an example of why that's not true. That is a proper impeachment. It goes directly to the false statement that she made on the stand. The court's decision to admit Leonard's testimony regarding an incident that occurred 9 years before publication of the op-ed served no legitimate purpose. That is not true. It definitely served plenty of purpose. In that it was going into the idea that she, in fact, was the abuser here. Mark Feeds, thanks so much for your super chat. Says, question, will oral arguments be televised/streamed? Some jurisdictions will allow cameras in the courtroom for oral arguments. I don't know if Virginia is one of them. So, but if it is, I'll be live streaming it. I'm sure plenty of other people will also be live streaming it as well. So thanks for the question. Okay, 5, the trial court's evidentiary rulings encouraged the jury to award damages unrelated to the op-ed. The trial court's erroneous evidentiary rulings also left the jury without crucial evidence regarding Depp's reputation and therefore prevented the jury from accurately assessing any harm proximately caused by the op-ed. First, the trial court erroneously excluded as hearsay articles relevant to Depp's reputation prior to the publication of the op-ed. The articles, however, were not hearsay, as Heard sought to admit them, not for the truth of the matters asserted in the articles, but to show the state of Depp's public reputation prior to the publication of the op-ed. Second, the trial court excluded relevant evidence related to the UK proceeding, including the Sun article and the UK judgment. At a minimum, the jury should have been permitted to determine whether it was appropriate to apportion any claimed reputational damages between the op-ed and the Sun article. Indeed, the trial court agreed that this evidence was relevant, but it nevertheless precluded Heard from introducing the Sun article, the UK judgment, and published media reports regarding the UK proceeding. Similarly, by precluding Heard from admitting the UK judgment, the jury was left with a false impression about Depp's reputation. Because of the UK proceeding and the significant corresponding media attention, by November 2nd, 2020, the world already saw him as a domestic abuser. Nonetheless, the trial court kept that critical information from the jury. I don't know. There were a lot of articles that were introduced that showed that talked about his issues with drinking and drugs and all kinds of stuff. So I don't really buy that as an argument. Jordan Pollard, thanks so much for your super chat. Says the various writers of this brief were clearly not on the same page. There are admissions and contradictions throughout. Yeah. This is quite a patchwork right here. This is very different than the Depp appellate brief, which was much simpler, much more streamlined, and which honestly is better for your overall argument. This is definitely a lot of stuff that's just kind of been tossed in. Given Depp's claim that the op-ed caused him significant reputational harm, it was critical that the jury hear relevant information regarding his baseline reputation. Because of the trial court's decisions, Heard was prevented from establishing that Depp could not have been harmed by publication of the op-ed because he already had a terrible reputation. Not like this one. Thus, while the jury was allowed to hear testimony of Depp's harm as far back as 2016, the jury was not able to fully assess the reputational harm unrelated to Heard's op-ed or the impact of a judgment that found Depp to have committed acts of domestic abuse, including sexual violence. As discussed more fully below, Infra Section 3E, the impact of this error was compounded by the separate error in permitting Depp to claim damages based on conduct unrelated to the op-ed, including the 2016 restraining order. All of this resulted in an indefensible $10 million compensatory damage verdict and $5 million punitive damage verdict, a verdict that demands reversal. Okay. Let me take a look here at where we're at. Okay, got a bit of a ways to go. Okay. B, the trial court erred by not dismissing the claim based on the headline for the web version of the op-ed because the evidence established that Heard did not publish it. Okay. The trial court erred by not striking evidence or setting aside the jury's verdict based on Depp's failure to prove a required element of one of his claims that Heard published the challenged headline of the online version of the op-ed, I spoke up against sexual violence and face our culture's wrath. That has to change. Publication by the defendant is an essential element of a claim for defamation. In reviewing a trial court's denial of a motion to strike evidence or set aside a jury verdict, this court considers whether the evidence presented, taken in the light most favorable to the plaintiff, was sufficient to support the jury verdict. The undisputed evidence established that the Washington Post drafted and posted the headline without Heard's knowledge. Heard testified that she did not notice the headline when she tweeted a link to the op-ed. Thus, there's no evidence that Heard published the headline. Well, no, that's not the same thing. They're saying that there's no evidence that Heard published the headline just because of the fact that she testified that she did not notice the headline when she tweeted the link to the op-ed. That is not the same thing. There is evidence that she published it. It is right there in the tweet itself. She can say that she didn't notice it, but the jury can also look at her testimony and say, I don't believe you when you say that. So there is evidence. They just want to say that it's not not sufficient evidence, we could say. Indeed, Depp effectively conceded this, his theory being that Heard republished the headline when she later tweeted a hyperlink to the op-ed. But courts consistently have held that providing a hyperlink does not constitute republication, even in a tweet that favorably references the article. Well, she didn't just tweet the link to it. She tweeted it and she said like something along the lines of, I wrote this. So this is not a good argument either. There's simply no evidence that Heard published or republished the headline. No, that's not true. No, again, no evidence. There is evidence. You just want to say that it's insufficient evidence. Thus, the trial court erred in two ways. First, the trial court's refusal to exclude the headline from evidence led to the introduction of irrelevant and prejudicial evidence and arguments about whether Depp had committed sexual violence against Heard, a phrase that does not appear in the challenged portions of the op-ed authored by Heard. As opposed to other forms of abuse, the word that Heard did use, thus infecting the jury's verdict as a whole. Second, because the jury awarded to Depp $10.35 million for all three challenge statements together, there is no way to know how much of the award is attributable to the headline that Heard did not publish. The only remedy for these errors is to grant a new trial on both liability and damages, but at a minimum, the second error requires a new trial on damages. No way. The trial court improperly instructed the jury on actual malice, they say in Part C. The trial court refused Heard's proposed jury instruction CC, which set forth the communicative intent prong of actual malice that Depp was required to prove by clear and convincing evidence for his defamation by implication claims. As a result, the instructions given to the jury on actual malice were missing this crucial component of the standard, and a new trial on liability, therefore, is required. The trial court gave two jury instructions defining actual malice. Instruction AA addressed only the falsity prong of actual malice. Instruction BB correctly clarified that actual malice is not established by ill will or hatred. Heard's proposed jury instruction CC, which the trial court refused, addressed the communicative intent prong of actual malice. that must be established when here the claim is for defamation by implication. That is, the jury should have been instructed that it also must find by clear and convincing evidence that Miss Heard either intended to communicate the defamatory implication or knew of the defamatory implication and was reckless in regard to it. So, but what actually was the instruction? Give me a second here. When considering whether a jury instruction was properly refused, the evidence is viewed in the light most favorable to the proponent of the instruction. If a proffered instruction finds any support in credible evidence, its refusal is reversible error. As explained above, Depp presented no evidence that Heard either intended to communicate through the op-ed that he had engaged in domestic abuse or knew of the defamatory meaning and was reckless in regard to it. To the contrary, the evidence showed that Heard made significant efforts to eliminate any such innuendo. The trial court's improper refusal of proposed jury instruction CC requires reversal of the judgment and remand for a new trial. Well, conversely, though, there was also evidence that the ACLU and Amber Heard were trying to make the op-ed the most impactful possible, right? That was a word that kept coming up, was how can we make this more impactful in their editing process. So an argument can be made that there actually was in fact evidence showing that she made that she intended to communicate that he had engaged in domestic abuse. Okay, Part D. The jury verdicts are inherently and irreconcilably inconsistent. Jury verdicts that are irreconcilably inconsistent cannot stand. If there is no reasonable way to harmonize the verdicts based on the evidence presented at trial, a new trial should be granted. Well, we were able to do that ourselves. You can reconcile them. To reach the verdict against Heard on Depp's claims, the jury necessarily found that Heard had not been abused by Depp and that she knowingly lied in stating that he had abused her. Yet, at the same time, to reach the verdict in favor of Heard on one of her own defamation claims against Depp, the jury necessarily found that Heard did not lie about being a victim of domestic abuse at the hands of Depp, specifically during the May 21st, 2016 incident preceding the restraint. That's not what that means. That's not what that means. That means that it was a lie to say that she came up with an elaborate hoax with all of the details of roughing up the place and spilling some wine and all this kind of stuff. So no, this is misstating the meaning of these various rulings or verdicts, I should say. Thanks so much for the super chat. My surname is pronounced Fittis, but good effort. Oh, thank you. Okay, Mark Fittis. Now I know. Thank you so much for the super chat and for the correction. Thus, the trial court erred in declining to set aside the jury's verdict against Heard on the ground that it is inherently and irreconcilably inconsistent with the verdict against Depp. The judgment against Heard should be reversed and the case remanded for a new trial on Depp's claims for this reason. No. We are able to reconcile those two verdicts. As kooky as they are together, we can reasonably reconcile them. Part E, the jury's damages award is excessive. Oh, I don't know about that. The Virginia Supreme Court has instructed that courts have the duty to correct a verdict that plainly appears to be unfair or would result in a miscarriage of justice. Setting aside a jury verdict is necessary when the award is so excessive that it shocks the conscience, creating the impression that the jury was influenced by passion, corruption, or prejudice, when the jury has misconceived or misunderstood the facts of the law, or when the award is so out of disproportionate to the injuries suffered as to suggest that it is not the product of a fair and impartial decision. If the size of the verdict bears no reasonable relation to the damages disclosed by the evidence, it is manifestly unfair. Okay, no. We heard so much testimony about him losing out on more than $10 million worth of damages, of work through damages. A trial court's denial of a motion to set aside the verdict as excessive is subject to review for abuse of discretion. Again, abuse of discretion. So this is a high burden for Team Heard to accomplish. To overcome. Depp's damages are limited to the narrow period between the publication of the op-ed and the issuance of the UK judgment, December 18th, 2018 to November 2nd, 2020. Depp failed to prove any pecuniary damages resulting from the op-ed during that time, and he did not seek emotional distress damages, leaving reputational harm as the only possible source of damages. The jury's verdict of $10 million in compensatory damages is grossly disproportionate to any reputational harm the op-ed could have caused during that small window. First, there is no evidence upon which the jury could rely to determine that Depp suffered any pecuniary loss because of the op-ed. No way. There was, to quote Amber Heard, mountains of evidence. There were plenty of people that were testifying about the movies that he lost out on and the how much he made in the years prior to the op-ed, and then how that suddenly had a steep decline immediately after the op-ed came out. There was plenty of testimony and evidence on this. Andy, the game maker, thanks for your super chat, says, when would Waldman wield wings on a wing glider while wearing a Walkman? I don't know. I don't know the answer to that question, Andy. But I appreciate the super chat. Thanks, brother. Depp principally claimed that he lost a role in Pirates of the Caribbean 6 because of the op-ed, but the trial record does not support such a conclusion. But that is up to the jury, dude. As an initial matter, Depp failed to establish that he actually had the opportunity to act in Pirates 6 and then lost it. He did not have a written contract for the film because there was explanation for that. Even before the op-ed was published, the media reported that Depp would not be in the film, and his agent testified that Disney was non-committal about giving Depp the role. At any rate, Depp testified that he would not have agreed to play a role in Pirates 6 even for $300 million and a million alpacas. That was after he had already been fired from it. So many points here that are just poor arguments. Depp also did not prove that he lost the opportunity to appear in Pirates 6 because of the op-ed. Disney's corporate representative testified that no decision maker within the company has ever said that they would not cast Depp because of the op-ed. I don't know that that's entirely accurate. If I remember correctly, I think that they were talking about how they didn't have anything in writing. Like they didn't have anything taken down in emails or what have you, which is probably conveniently how they do these things specifically for situations like this. Nor did Depp present any evidence that he lost other opportunities because of the op-ed. For example, Depp still has an endorsement deal with Dior, which began in 2015. Yeah, Dior was the one company that stuck by him through this whole thing. Every other sponsorship or endorsement or what have you left. Given that the jury could not have awarded Depp damages for any pecuniary losses based on the evidence at trial, and Depp never sought emotional distress damages, the only damages the jury could possibly have awarded were for general reputational harm. Even for non-pecuniary damages, however, a jury still must award damages that resulted only from the defendant's wrong and not from other causes. There was so much evidence on that. The trial court improperly admitted evidence that encouraged the jury to award damages for conduct unrelated to Heard's op-ed, specifically evidence of reputational harm stemming from Heard's 2016 restraining order. Depp's trial theme was a plea for the jury through its verdict to rectify the damage Depp suffered as a result of the restraining order. On May 27, 2016, Ms. Heard walked into a courthouse in Los Angeles, California, to get a no-notice ex parte restraining order against Mr. Depp, and in doing so, ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp. Today, on May 27, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for her lies. These sentiments permeated the entire trial. According to Depp, when Heard obtained the restraining order, he lost nothing less than everything. He explained when the allegations were made, when the allegations were rapidly circling the globe, telling people that I was a drunken, cocaine-fueled menace who beat women, suddenly in my 50s, it's over. You know, you're done. Just because, thanks so much for your super chat, says, by that logic, how could Amber have suffered harm from the Waldman statement when she then got her biggest film role? Yeah, agreed. Excellent point. Yeah, and thanks so much for the super chat. In fact, Depp's testimony began with an explanation of why he brought this case. About 6 years ago, Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based in any species of truth. Depp also testified that after the public became aware of the restraining order, the bad news about him was multiplying throughout social media as well. Even Depp's expert, Doug Banya, who Depp retained to analyze the impact of the allegations on Depp's reputation, could not say that Depp's reputation on public image were affected by the op-ed as opposed to the events in 2016. I don't recall that testimony. It may have been. But there were other experts that testified, or other individuals, I should say, that testified about his actual economic loss. Mark Fittis, thanks so much for your super chat. Says they seem to forget that abuse DV/SA has no gender. Yeah, the Amber Heard side definitely wants to make people forget that, unfortunately. Because Depp improperly was allowed to suggest that the jury could award damages based on statements Heard made prior to the publication of the op-ed, and the jury was not informed of the outcome of the UK proceeding. The jury's damage award is wholly out of proportion to the reputational damage Depp actually could have sustained as a result of the op-ed. It is clear from the size of the compensatory damages award that the jury intended to award damages not just for the op-ed, but for all of the negative publicity that Depp had received since Heard first accused him of abuse in 2016 and continuing after the UK judgment. That is an impermissible basis for damages in this case. So, okay, but again, this is under an abusive discretion standard. So where was there an abusive discretion in finding for these, in finding the damages number, right? Like how do you know? How can you possibly say that the jury awarded damages based on the statements that Heard made before the op-ed or based on the UK proceeding? This is just, it's not a compelling argument to me. At a minimum, the jury's excessive damages verdict should be reversed and the case should be remanded for a new trial on damages. Conclusion: for the foregoing reasons, Heard requested this court reverse the judgment against her and either A, enter judgment for her or dismiss Depp's claims without prejudice, or B, remand for a new trial. Woo! We made it to the end. Yeah. No, we don't want any of those things to happen in this case. No new trial. Don't want Depp to go through that all over again. He won fair and square. And certainly not for a simple reversal. Okay. So that about does it. There's some decent arguments here. I think that the one that's the most interesting to me personally is the argument about him being a public figure or them being public figures and not being allowed to win by defamation by implication with a public figure. I think that's the most interesting one. Definitely no guarantee that the court is going to go for that because it's only a handful of states that have gone for that. Yeah. So overall, I'm not terribly convinced by these arguments. I don't think that they are the strongest arguments that could possibly be made. But we'll see. We'll see what happens. I'm curious to see what the reply briefs are going to look like, especially the reply brief to this one. I anticipate there will be a lot of Ben Chew snark. But yeah, that's I don't know. I'm thinking Depp is still likely to win this one. He has a really good appellate brief on his side about the Adam Waldman statements. So if you guys haven't seen that, I should have linked to it in the description. But I will link to it in the description below if you haven't already seen that. And then I still might do a VOD on this one just to do the bare bones, like what is it that Amber Heard's team has argued in this brief. Let me know if you guys are interested in that, because obviously this is a bit of a long live stream for anybody to sit through and read the entire document. Well, most of the document with me here is it's a bit of a time commitment. So anyhow, that for me about does it. Thanks so much for joining me today. Loved seeing folks from all over the place in chat today. And thanks, of course, to the mods, as always, for helping to usher discussion in a way that is kind and respectful and allows for people to have a difference of opinions. So, alrighty. I hope you guys have a great rest of your Tuesday, and I will see you guys in the next video.